Divorce and trusts. This is a fascinating topic. Upon divorce between parties, it becomes necessary to divide the joint estate between the parties, should they be married in community of property. Suppose the parties are married out of community of property. In that case, it becomes necessary to calculate the accrual payment from one to the other, should the accrual system apply to their marriage. In both cases, it is necessary to consider the estate or estates of both parties, which include the assets and liabilities. These assets which are being considered include movable, immovable or even intangible assets which belong to each applicable person. Such a person would have an absolute real right over such assets by being purchased by them under their control or even registered in their name. In summary, whenever a person is considered as the owner of an asset, such asset may be considered for purposes of dividing the joint estate or calculating the accrual. This means that your estranged partner may, in some way or the other, share in your assets after your divorce. Identifying assets for purposes of dividing the joint estate or calculating the accrual can, however, be more complicated than it seems, especially when there are trusts involved. A trust is a legal arrangement whereby control over property is transferred to a person or organization, the trustees, for the benefit of someone else, the beneficiary. You can register two types of trusts, namely an inter vivos trust and a testamentary trust. The trustees will be deemed to hold or have vested in them the property of which they are not the owner in their own right. A trust is a separate legal entity and as such may own property in its name. The trustees will have the fiduciary obligation to hold, use, deal or dispose of the property, but only for the benefit of the beneficiaries. The above tells us that assets registered in a trust cannot be considered as an asset belonging to a person, and as such asset cannot form part of the joint estate or the accrual. Neither spouse may therefore benefit from an asset registered in the trust. In some cases, assets may have been moved to a trust to avoid sharing it with your soon-to-be ex after a divorce, or in some cases, assets were moved to a trust to ensure that the beneficiaries will benefit from them in the future. Beneficiaries in cases of divorce are usually the children born between the parties. The first mentioned trust may face some issues should the divorcing spouse contend that its assets should be considered in the divorce, or should they challenge its validity in court. There are strict rules when it comes to the creation of trusts, how it should be administered, and their purpose. A trust may be declared invalid, especially if it was created for the wrong reasons, such as to commit fraud. In other cases, the court may consider the trust's assets when dividing the joint estate or calculating the accrual. It is therefore crucial to consider trusts if there is any when you get divorced.